Good morning, everyone. I'd like to address an issue of national importance today, and that involves the issue of immigration and immigration policy. You will know that in 2001, the Progressive Labor Party created the category of permanent resident certificate holders. That category was created to provide a measure of justice to those long-term residents who had been in Bermuda before July of 1989, against the backdrop of the government in 1989 taking a position that there will be no further discretionary grants of Bermuda status. The policy of avoiding and not allowing discretionary grants of Bermuda status has been a policy that's been in place since 1989. Every successive government has embraced that policy, and there had been no plans to change it until such time as we came to a position where there would be a comprehensive reform of the immigration legislation in total. You will know that the recent judgment by Chief Justice Kewley has created an avenue for Bermuda status for those residents who hold PRC and therefore who had been here before 1989. The numbers, as you've heard, have been presented in varying levels, from as low as 1,300 to as many as 6,000. The fact of the matter is that it represents a significant number who, if granted in one foul swoop, would have a significant impact on Bermuda and opportunities for Bermudians. It is as a consequence of this judgment by Chief Justice Kewley that the Progressive Labor Party proposed an amendment to the Immigration and Protection Act of 1956, which was designed to align the law with what had been in policy since 1989. The amendment was to repeal Section 20B of the relevant Immigration Act. You will note that last Friday in Parliament, the One Bermuda Alliance government spoke in unison in rejecting this amendment, and not only was it surprising that it was rejected in unison, but the manner in which it was rejected indicates that there is a concern about extending status to an even larger number of residents. Our position in 2001 and our position today is that there needs to be a reform of immigration policy. It needs to be holistic. It needs to take into consideration the rights of all who live in this island. It needs to take into consideration the rights of Bermudians, the PRC holders, long-term residents who are not PRC holders, and those who are here on shorter-term work permits. All have rights. Our position is that rights, however, are not absolute, and the rights that each and every one is entitled to, as well as privileges, need to be balanced with the interests of others. And so we have called for government, in the wake of the rejection of the immigration amendment, to suspend all applications for Bermuda status and initiate a substantial review of this policy so that we can have a policy that's determined by the conscious decision of Parliament and legislatures, rather than a policy that has resulted because of an interpretation by the Chief Justice. This is an issue that affects every single Bermudian. It clearly affects every single PRC, and we need to have a rational, careful analysis of how we proceed. The fact of the matter is that to establish a system whereby up to 6% of one's population can gain status, the equivalent of citizenship in one foul swoop, is unprecedented. No country in the world has an immigration policy or a citizenship policy of such a magnitude. The previous policy was that up to 40 Bermuda status grants would be granted in any given year, and that ended in 1989. If all those who are eligible today apply and receive Bermuda status, it would double what would have been provided had we continued with 40 per year since 1989. So that just gives you an idea of the the impact that it could have in terms of employment opportunities, property rights, and so forth. It will determine the outcome of any election, because our elections are determined by very small numbers of voters. And so to place a significant number, 1,000, 2,000, you pick the number, on the voters list would have an indelible impact on the election results. Now, there is a lot of talk about the need to make a just and human rights decision. You should also know, though, that notions of equality before the law have always had to take into consideration the sizes of the respective populations that are to be affected by it. You will know that all Bermuda status holders have the right to live and work anywhere in the European Union. That's a result of agreements the European Union has adopted. But it is equally true that European Union citizens and UK citizens do not have reciprocal rights in Bermuda or any of the other overseas territories. So on the one hand, we have rights to work and live in the EU and the UK. Those nationals do not have reciprocal rights in Bermuda. And the rationale for that has to do with size and the impact of large groups migrating on relatively small populations. It is that same principle that we have adopted here and now needs to be brought back to the forefront. So we are calling on the UBA government to step back, realign itself with the 1989 position, and begin the process of substantial, holistic review of immigration policy and reform. Thank you. Questions for 1 minute?
Okay, my question is,
Yeah.
you talked about the impact on employment opportunities, but PRC holders already have the right to work here, don't they?
Yes, they do.
So what's the impact?
Oh. Well, you would know, Mr. Johnson, that there are some categories of employment where Bermudians take precedence in terms of selection for employment over all others, as is the case in every other country. And so every time someone else gets added to that role, or that roster of Bermudian, they will fall under that category, and they therefore will have the advantage of anyone else who is not Bermudian. That's the current policy.
So is it, the position is that PRC holders don't have the same employment rights?
That is correct.
Sorry.
Hey, your minute's almost up.
No, go ahead.
I don't know based on the law. Are you suggesting that the government has already decided to go along with this?
Well, we have, first of all, attempted to persuade them to hold to the status quo ante. We have called on them to support the legislation. They did not support it. We attempted to rise and report progress. In other words, keep the legislation on the books and then work with government to see if any amendments could be made that they would support. They rejected that. So the legislation, no such legislation can now be brought back before Parliament, this parliamentary session, because the bill was rejected. One or two members have said the government intends to suspend applications. We have not heard an official statement from government in this regard, and we are calling on government in part through this medium to actually affirm that position.
There seems to be some concern about the Chief Justice ruling.
Mm-hmm.
Surely Parliament supersedes the judiciary of this type of thing?
No. We have a system of government in which you have executive power, legislative power, and judicial power. The courts are independent of Parliament and independent of the executive. The Chief Justice has provided what I consider an erudite opinion, and he has ruled, and as far as the law is concerned, the law is based on his ruling until such time as that is appealed and or repealed. So the Chief Justice played his part as he is meant to do under the Constitution. The legislature and the executive now need to play their part to ensure that the law is in line with what policy is meant to be. And we want the government to reaffirm the policy that has been in place since 1989.
In terms of the judicial decision, is this an instance of legislating from the bench?
I've heard that term before, and others have made that position clear. And clearly, you now have a new interpretation of the Immigration Act, which provides for a new policy direction. So it's very clear that the decision by the Honorable Chief Justice has created new policy based on this interpretation. And no legislature wants to see legislation from the bench because that means it's based on an interpretation of the law rather than the explicit objective and purpose of what legislators are meant to be accomplishing. So it is legislation from the bench.
On the back of a previous question, is this a done deal, in your opinion? I mean, the window for appeal is closing. Is this a done deal?
Nothing's a done deal in politics. You would know that the window expires this week for launching an appeal, and that's at a purely legalistic level. There are still other remedies that could be set about, and we will pursue all remedies available to try to achieve an objective that really balances the interests of Bermudians and those long-term residents.
In your capacity as chairman, have you attempted to prevail upon the minister the confusion that could arise from this?
Well, with respect, there is no confusion. I think there's a great deal of clarity about what the outcome could be. And yes, I have met with Minister Fay, and I have tried to impress upon him the need for a balanced approach and the need for holistic review of policy, and try to encourage him to support our direction. Clearly, it didn't work.
And I use confusion, I didn't mean misunderstand my social unhappiness.
Oh, there will be social unhappiness because you will have Bermudians who are out of work, facing a challenging market in terms of buying property, and when you put into play an additional 1,200 participants, that just changes the dynamics on any level. It just changes the dynamics, and so it will be a matter of concern that the Bermudian will feel, even if they don't fully grasp the implications today. They will feel the impact. I think that the more people come to appreciate the magnitude of this decision and the magnitude of the possibilities, I think people will rightfully have a genuine concern about the state of affairs and their opportunities in their country.
Okay, I've got two questions. Given that this was a judicial decision, but you're responding so effectively, is the PLP minded to go the judicial route? Are there avenues in terms of appealing or judicial review of the decision, since it didn't seem to take into account the wishes of Parliament?
Right. Well, strictly speaking, the courts are not required to take into account the sentiment of Parliament. But the idea of an appeal by someone other than government is something that is currently being examined, and by Friday, we will know whether that's something that could in fact be done. But it is an issue that has been put on the table.
Second question. You made the analogy of the human rights rationale in terms of the non-reciprocity of residency between the European Union citizens and Bermudians. I'm curious as to how you're saying that it's a similar rationale here, because the PRCs are only residents, they're not immigrants. Are you implying that the PLP wants to keep the door open for removing residency from these states?
Of course not. It's the PLP that created permanent residency for this group of people. So by no stretch of the imagination is the PLP considering or having ever considered removing residency. The comparison, IO, is that the decision about reciprocity with respect to the EU and non-reciprocity was based on the impact based on the comparative sizes of populations. That's the argument. And so when you look at the issue of status and the magnitude, it's in relationship to the sizes of the population. And that's why awarding 40 Bermuda status grants a year as opposed to 1,200 in a given year has an altogether different impact on the community.
Should these folks who are born here, who identify themselves as culturally Bermudian, shouldn't they have an opportunity to be granted status? It's not discriminatory to deny them that opportunity.
Well, you know that there are very few countries in the world in which people who are born, who acquire citizenship just because they're born in a country. First of all, countries that have had immigration policies that were designed to attract people to their country, like Canada and the United States, have granted citizenship to people just by right of birth. Very few countries do that, and in a small country like Bermuda, with a workforce, a work permit workforce, sometimes of 12,000, you just could not create a similar set of policies. So you have to balance the interests. Having said that, there nevertheless needs to be some kind of a vehicle so that the rights and privileges that people who've been here for a long time can actually achieve. But it needs to be as a deliberative policy. It can't be because the Chief Justice has ruled in a particular way. Because by extension, this decision only applies to people who were here before July 1989. What about the people who came here in August of 1989 and have been here ever since? The argument that you make could also be applied to them. Should they not also be entitled to a greater measure of rights and security? So you have to look at it holistically. It's not just the PRCs, it's the issue of those who are also long-term residents but not PRCs. So what kind of policy do we want to have for this country? You cannot do it in piecemeal fashion, and no disrespect to the Chief Justice, but the effect of his decision is to implement a piecemeal reform when what's needed is wholesale reform.
Now that term limits have been abolished, are there any mechanisms left to prevent growth of the PRC population?
Well, the current legislative framework allows for other people to get PRC. The current framework allows for people to be here for 25 years without any security. And so you have a similar situation emerge again, because everyone who came in August 1989 or later and who stays for 10, 15, 20 years will also be making claims for a measure of security. And so that's why you need to have a proper, holistic examination of policy. Like I said before, every country in the world has a set of quotas on how many will be awarded citizenship in a year, how many will be awarded permanent residence or green card and so forth. We don't have that, and we need to examine it, and we need to create something like that.
The numbers on this, could you just clarify? You mentioned earlier that a lot of numbers have been floated out there in terms of how many people will be affected. There's been 1,200, 6,000.
Right.
Just clarify how many people stand to be affected
Right.
by this.
If you look at official government data, and I don't have them in front of me, but roughly there are about 1,300 people who currently hold PRCs. There are currently about 1,200 spouses of PRCs and over 1,500 children of PRCs. And if you adopt the position that you should have laws and policies in place that do not fragment families, do not weaken families, and afford all families, people within that family group, the same rights, then you talk about harmonizing rights for families as opposed to individuals within a family. And so the numbers could be, I heard numbers as high as 8,000, but it is well over 1,200. And
so this opens the door for not only the PRC holders, but also their spouses and their kids to be granted status? Is that what you're saying?
Exactly. Because any person who holds status, their spouse is entitled under law to status. So it varies from 5, 7 to 10 years residence, but anyone who gets status and who is married, their spouse is entitled by law to status, and therefore also with their children.